Hi, hello everyone. In this video, we are going to learn about section 482 of CrPC, which deals with inherent power of High Court. So, what are these inherent powers? We are going to understand this in detail, and besides this, we are going to interlink section 397 of CrPC with section 482 of CrPC. So now let's start. What does section 482 says? So if we go down and read section 482, if you are having your Act, you can read from there too. So basically, when we start, it says that nothing in this code shall be deemed to limit. So when we are seeing the provision of the Act from the Act, it is saying that nothing in this code. That means code means CrPC. So it is trying to say that any provision of CrPC is not limiting this section which 482. So entire code is not going to limit the power of section 482 or the power allotted to High Court by section 482. So first line is that nothing in this code shall be deemed to limit or affect the inherent power of the High Court. So now this is clear that whole CrPC is not going to affect or in any way limit the power of High Court which has been allotted to High Court through section 482. Then it says to make such orders. Now we are going to see that the powers provided to High Court through section 482 are three in numbers. First one is when we read the Act, we are going to understand this, that to make such orders as may be necessary to give effect to any order under this code. That means, which I have written here on the point number 3 on your screen, order passed ineffective. That means if any order has been passed under CrPC, and to make it effective or to implement that order, if there is some interference needed of High Court, then in that situation High Court can make that order through which the order which already has been made under CrPC will become effective. So if in any way any order has been made under any provision of CrPC and that order is not becoming ineffective or effective, in that situation High Court can order anything which it wants to make that order effective. So this is the first thing for which section 482 can be applied. So please do remember that 482 can be used only for these three purposes which have been given under section 482. So first purpose is to order uh, as may be necessary to give effect to any order under this code. So this is the first thing. Then second thing is to prevent abuse of process of any court. So if in any way the court is abusing its power, in that situation we can approach High Court, and through High Court we can ask the High Court to prevent the lower court to misuse their power. Then the third thing is to secure the end of justice. This is the most important thing, because through this the power of or the ambit of section 482 has been made endless. So for anything where the court deems fit that the justice is not getting made, in that situation High Court can interfere in that scenario by using section 482 of CrPC. So now it is clear to us that only for these three purposes section 482 can be used. Then we need to understand this also, that if in a situation where any specific provision has been given under CrPC, like if any particular thing has been stated in any particular section of CrPC, in that scenario we cannot use section 482 of CrPC. Like if the maintenance section have been provided under 125 of CrPC, so if we want maintenance from anyone which is covered under section 125 of CrPC, then in that scenario we have to use section 125 of CrPC only. We cannot use section 482 of CrPC. So if any specific provision has been provided under CrPC, then we have to use those specific provision. Or if there is no specific provision, there is no existence of any specific provision, if we are not having something in CrPC, then in that scenario we can use section 482 of CrPC. Like for example, if we read section 320, then there are certain provision which says that these offenses are compoundable offenses. That means even if a party involved in the offense is compounding with the other person whichever is involved in the offense, and they're going before the court that we have compounded the offense, then in that scenario court can close down the proceedings. But there are certain offenses which are not given which are not covered by section 320 of CrPC, and there is no specific provision to end those um, proceeding if there happens some compounding between the parties. So in that scenario we can use section 482 to end or to quash the proceedings so that no further proceeding should take place. So in this way we can use section 482 of CrPC. Then we also need to understand that if we are using section 482 of CrPC, it is important that the inherent power cannot naturally be invoked in respect of any matter covered by the specific provision of the code. This we have understood. Second thing which I am trying to make you understand is that it cannot also be invoked if its exercises would be inconsistent with any of the specific provision of the code. So if in any particular provision something has been stated by our lawmakers, then we cannot do something inconsistent with that particular section by using section 482. So I hope that this thing is clear to you. Now as we know that this code has been framed in year 1973, so we cannot expect from the lawmakers that they would know all the situation which are going to or likely to arise in the future. So it is also common thing that when we make a law, there are certain lacunas in that law. They will we will come to know those lacuna after practicing only, that this specific provision is somewhere having some loophole in that. So we come to know this thing only after doing practice. So our lawmakers has ensured that if any new scenario arises in the future, or if any lacuna exists in our law, then in that scenario if our law will be inflexible, that will make this the application of law very difficult. So for that also we have introduced, or our lawmakers introduced section 482, so that the inherent power of courts would make it uh, powerful enough to do whatever it want to do to make end of justice. So this is one of the important reason why the lawmakers has had introduced section 482 in this code. Now we also need to remember that this section is only applicable to high court only. No lower court can use section 482 to do anything. Now the question arises that if this section is only applicable to high court, then what would be the scenario if we go to the Supreme Court? So Supreme Court in itself has ensured that whatever powers high court has, we are also having those powers by using article 136 of the constitution. So if Supreme Court wants to do something which high court can do using section 482, that same thing can also be done by Supreme Court also by using article 136 of constitution. So Supreme Court itself has ensured that yes, we have all the powers which a high court has. So now this thing is clear to us. Now there are certain things which we need to understand. We have understood that this is applicable to only criminal proceedings. High court can only use this section 482. Now if we come to some illustration where we have seen that to meet end of justice, or where there are no specific provision in the code, we can use section 482 of CrPC. So let's see one example, that quashing of FIR is such an example where there is no specific provision existing in the CrPC to quash those proceedings which are not covered under section 320 of CrPC. So in that scenario we need to approach high court to end those proceedings, to quash the FIR. So in which scenario, in which condition high court quash the FIRs? Because lower court cannot end the proceedings because they are not covered under section 320 of CrPC. So high court sees certain scenarios in which it quashes the FIR. It will not quash the FIR. You say that the proceeding which have been initiated have no enough evidences. So if if a particular case do not have enough evidences, in that scenario it is the duty of trial court to appreciate the evidences and then conclude whether the accused is guilty or not. So you cannot approach the high court in a scenario where you says that there are no enough evidences. Yes, you can approach the high court in a situation where FIR has been lodged and there are no evidences. So there is a difference. When you say there are no enough evidences, that means it is the duty of trial court to conclude whether the person is guilty or not. But if you says that there are no evidences and the FIR has been registered against you, that means the prima facie you haven't committed that offense. In that scenario, you can approach the high court to quash the FIR which have been registered against you. So there are situation in which you need to see that in this scenario I can approach high court and in this scenario I cannot approach high court. Let's take a similar example, like an FIR have been registered, and when you read the facts of the FIR, it does not constitute a cognizable offense. So we know that if a offense is not a cognizable offense, then in that scenario FIR should not be registered. When we read section 154 155 of CrPC, and if it's a non-cognizable offense, then the scenario is different. You cannot initiate the investigation without the permission of magistrate. All those things happen. So if a FIR has been registered, and when you read the facts of the FIR, you comes to know that this is a non-cognizable offense. In that scenario also, you can approach the high court to quash the FIR that this is a non-cognizable offense and FIR have been registered in this case. Similarly, if we see that when allegations are made against you in an FIR and those allegations are so absurd or inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused, in that scenario also you can approach the high court and get your FIR quashed. There are certain reasons or certain ways in which you can approach high court to quash your FIR. Similarly, if somebody reads the FIR and it is obvious from the facts that this FIR has been registered against a person just for private and personal vengeances, in that scenario also you can approach high court and get your FIR quashed. So we can see that how we can use section 482. So I hope till here you are clear what we are discussing. Then if it comes to section 397 of CrPC, it is a revisional section, call for record. So section 397 says that if we come to subsection 2 only, because we can interconnect this section only, it says that if there are certain interlocutory order, you cannot go to appellate court to do revision. So in this situation, what option would the parties would have? Because it has been restricted through section 397 subsection 2 that only when your proceeding has been concluded, only then you can approach the appellate court for revision. So if any interlocutory order has been given by the court, then in that situation you cannot go into revision. So what option do we have? So here also we can use section 482. So now we come to understand that there is no specific provision in CrPC which says us that we can go against interlocutory order in revision. So in this situation we can use section 482 of CrPC to go to appellate court in a scenario where we says that in this order injustice has been caused to us. So this is how we can use section 482 to make end of justice. Similarly, when you will read section 397 subsection 3 of CrPC, read with section 397 subsection 1, it says that if you want to go in revision, you can either go to session court or you can go to high court. If you goes to session court, then you don't have option to go to high court, and if you goes to high court, then it is the end of revision jurisdiction. So if a party has gone to session court, and their revision has been dismissed, so what option they have to go to high court? In that scenario they can use section 482 of CrPC to go to high court. So that means and when we read section 482, there is nowhere written that we have to read section 482 of CrPC subject to section 390 subsection 2 or subject to section 390 subsection 3. So that's why we can use section 482 of CrPC, where CrPC particularly are restricting us from using basic fundamental things. but we need to take care that this thing should not be uh, happen just to misuse the power of section 482 of CRPC. So we have to take care that a particular question has been taken while using section 482 of CRPC, and I have made you understand that how Supreme Court has also ensured its power under section under Article 136 of Constitution, by stating that we also have same powers which High Court have under section 482 of CRPC. So this is all about section 482 of CrPC. If you are having any doubt regarding this, you can comment in comment box. I hope you like the video. Please do like the video and share it with your friends, and do subscribe to my channel. Thank you so much for watching this video.